I am here to talk to you about financial provision on divorce, I suppose the nuts and bolts, or going back to basics. And I also just wanted to say a wee bit about a case law roundup or update from 2020. So just in terms of an introduction, my name is Amanda Masson. I'm a partner in Harper Macleod in the family team. I wanted just to really go back to basics and sort of give a wee refresher about what the Act says, and then just talk a bit about gifted and inherited funds, because I think that's an issue which quite often crops up increasingly in practice. So I wanted to just touch as well upon what could maybe be done to help clients who want to ring fence assets at the point of marriage, or sometimes during marriage. Clients might come to you and say that they want to think about what we would call a post-nuptial agreement, which might help them to protect things that they're worried about. So I think it's helpful just to remind ourselves about the definition of matrimonial property. Section 10.4 of the Family Law Scotland Act 1985 defines matrimonial property as all the property belonging to the parties, or either of them, at the relevant date, which was acquired by them, or him, or her, I suppose, other than by way of gift or succession from a third party. For the marriage, for use as a family home, or as furniture or plenishings for such home, or during the marriage but before the relevant date. So unless a property is acquired for use as a family home, or furniture is purchased for that home before marriage, an asset will not be matrimonial property, with the exception of interest in pensions and life policies, although remember, values would be apportioned to cover the period of the marriage. Really what we're doing is taking a snapshot of the financial picture at the date of separation, wondering then if any assets might have been acquired before the marriage. Remember the exception for family homes or furniture that's been purchased for use in the family home. And then the next step would be to think, are any of these assets derived from gifts, inheritances from third parties? Remember too that anything that's acquired after the date of separation would also be excluded from the definition of matrimonial property. That's come up for me a few times in cases recently where a client has said, well, look, he's got another flat now. He bought it just after we separated. Why can't that be factored in? The reason is just that it doesn't fit the definition of matrimonial property. So when we've identified what the matrimonial property is, as you will know, the next step is to determine how or at what the property should be valued. Matrimonial property is to be valued at the relevant date, and that's defined in section 10.2 of the 1985 Act. The relevant date is the date on which the parties cease to cohabit, or the date of service of the summons or initial writ in a divorce action, whichever is earlier. There is one exception now. Any property which is to be transferred to one of the parties as part of the settlement or on divorce is to be valued at a date agreed for the parties, or in the absence of agreement, at the date of transfer, or a date as near to possible for this. So in practical terms, if a relevant date occurred a wee while before you're at the point of trying to resolve a case, it can be useful just to obtain an updated valuation. It typically arises in relation to houses. The date of separation is really quite important to identify and agree and lock in at as early a stage as you can, because it's the date that we use for valuing the various assets and taking into account any debts. It's a snapshot rather than a video approach to valuation, in contrast to the position in other jurisdictions, including England and Wales, where the sort of definition is maybe a wee bit more fluid. All we are looking at is what existed at the date of separation, the definition of matrimonial property. Sometimes there can be disputes about when the date of separation actually is. When did the couple separate? Sometimes it can be hard to pinpoint that specific date when a relationship is unravelling, but it can make quite a difference to the financial landscape. In one leading case on relevant date, parties were 10 years apart on when they considered the separation took place. There were various factors. They had a very different idea about when the marriage finally came to an end, such that they had to divorce. And what the court did was go for a date somewhere in the middle. Remember that there is a slight complication at section 10(7). When it comes to looking at periods of reconciliation, and this is something that's often overlooked, if there has been a long period of separation, and that's defined as at least 90 continuous days, and then a short reconciliation of less than 90 days, then we look at the earlier date of separation as being the relevant date. Otherwise, the earlier date would be ignored and the date of the final split would be the relevant date. And sometimes people can try to be quite tactical about the date of separation because it can make such a difference to the valuation of the property. I said earlier that the definition of matrimonial property specifically excludes property acquired by gift or inheritance from a third party. This really is quite an important issue to consider. If a wife were to acquire a house by way of a legacy in a will, or say a husband is gifted a sum of money from a relative, the property and the sum of money would not be considered matrimonial property. But remember that if property is converted during the marriage, even if it didn't start off as fitting the definition of matrimonial property, it can become matrimonial property by virtue of conversion. So if a spouse realises or sells inherited or gifted property during the marriage, the spouse is effectively converting it into matrimonial property. Conveyancers, you're at the forefront of these transactions quite often. To give an example, if you're instructed by a married couple or a couple in a civil partnership to buy a house in joint names, they intend to live in that, i.e. it would become the matrimonial home. One of them is introducing capital acquired before the marriage, either money that was inherited or gifted to him or her before the date of the wedding, or they might be buying a more expensive property together using all or part of the proceeds of sale of a property which was in the name of one of them before the marriage. There might be an unequal contribution towards the purchase. How would you treat that? Well, technically the house would be matrimonial property, the property that existed at the date of separation, but it would be subject to a source of funds argument when it comes to valuing the matrimonial property and more importantly, the division of the value of the matrimonial pot. Say, for example, you were acting for a husband who got married in 2000, bought a property in 2009, so during the marriage for £400,000, the mortgage taken was £200,000, but the balance of the purchase price came from money that your client inherited from his late father's estate. Title was taken in joint names. The couple separated in 2018. The property by that point is worth £600,000 with a mortgage left of £170,000, which leaves £430,000 worth of equity. The couple decide that they're going to sell the property on separation. Husband might instruct that from the sale proceeds, he wants to receive back his £200,000 from his inheritance, plus a half share of the remaining equity. So wife would receive £115,000, husband would receive significantly more. To your client, the husband, this might seem absolutely fair. Both spouses make the same amount of money, they made equal contributions to maintaining the property and all the bills during the marriage, sorry. The wife's view, of course, might be that this is wholly unfair. Title is in joint names, so why should wife not receive half of the equity, i.e. £215,000? So if we go back to basics, go back to the framework of the Act, the starting point under the 1985 Act would be that the net value of the matrimonial property shall be taken to be shared fairly, and fairness is a key concept, between the parties when it is shared equally. So a 50-50 split seemed to be fair. Or in such other proportions as justified by special circumstances. Then if we look at section 9(1)(a) of the 1985 Act, special circumstances are set out. A clean break principle underlines Scots law when it comes to separation and divorce. So, 50-50 split certainly delivers a clean break quite quickly and easily. Default mode is equal sharing, not great news for your husband client. However, the husband could be argued to have converted his inheritance into matrimonial property, but when we look at the legislation, there can be departures from that general principle of equal sharing to reflect special circumstances, economic disadvantage, where there's been no corresponding economic advantage, need for ongoing financial support for an adjustment period following divorce. I suppose the kind of standard period in Scotland would be 3 years at the most. Indefinite financial support post-divorce is very, very rare, but if your client had an argument under that grounds, it might be running. Looking at the example I mentioned, what the husband would need to argue is that there is a special circumstance in terms of section 10(6) of the 1985 Act that would justify a departure from equal sharing in his favour because of the source of funds used to acquire the asset which is in dispute, or the value of which is in dispute. So he'd be relying on section 10(6)(b) of the Act, which states that the source of the funds or assets used to acquire any of the matrimonial property or partnership property, where those funds or assets were not derived from the income or efforts of the persons during the marriage. And so what we're really saying is, okay, some of this value was accrued because of the inheritance, therefore it wouldn't be fair that that be forgotten about. The leading case on this is still Jacques against Jacques, number 3, and the citation is 1997 SC HL 20. It's a House of Lords case, so it does carry a lot of weight. The court held that there is a presumption for equality in the absence of any special circumstances justifying otherwise. There is nothing set out in section 10 of the 1985 Act which requires an unequal division whenever special circumstances are found. Unequal division must be justified, and each case turns on its own facts and circumstances. So far, things aren't sounding great for our husband who applied his inheritance. Further difficulty for husband in terms of case law is the decision of Lord Macfadyen in Cunningham against Cunningham, and that's 2001 Family Law Review 12. In that case, husband had received an inheritance totalling £214,000 from his grandmother. That was invested by him in a holiday home and also the matrimonial home, title to which was taken in joint names. The holiday home was worth £68,000 at the relevant date, and the matrimonial home was worth about £300,000. And approximately £100,000 of the inherited funds had been used to invest in the matrimonial home. And what Lord Macfadyen said in that case was, money used to purchase the matrimonial home is, in my view, devoted in a particularly clear way to matrimonial purposes, and the source of funds used is, in my view, less important than it would be in the case of other types of matrimonial property. So ultimately, he held that the value of the matrimonial home should be equally divided between the parties. However, and I wonder if this was just a sort of concession to the husband, his source of funds argument in relation to the holiday home was successful, and the whole value of the holiday home, the 68,000, was left out of account. And I think it was partly making a concession to husband, but also it really underlines that where gifted or inherited funds are used to acquire the matrimonial home, that's a particular purpose, a particular circumstance. I think there is a risk that a court would always treat an investment in the matrimonial home maybe slightly differently to any other kind of investment of non-matrimonial funds. And I think that's just because this is the home in which the spouses live, it's where the family live. It's, I suppose, the kind of linchpin of the marriage in one view. So this isn't a firm rule, and much will depend on the circumstances of any given case. For example, there was a case in 2013, Harris against Harris. Citation is Harris against Harris, 2013, Family Law Review 122, where the court said that Cunningham is not actually authority for the proposition that the source of funds argument will never apply to the matrimonial home, but it's a factor which the court will take into account in the exercise of its discretion. However, the effect of the decision is that the husband in our scenario would not be guaranteed to get back his inheritance. He would need to rely on his special circumstances argument in an attempt to recoup what he'd put in, and that would be entirely at the discretion of the Cherriford judge. I wanted just to mention as well a fairly recent decision of Lady Wise. It's a case A against A. I'll give you the citation later on, but Lady Wise observed recently as August 2020 that the application of inherited funds does not, she was really just underlining that it does not necessarily give rise to an unequal division based on a source of funds argument. So I think really you have to be going some to persuade the court that there should be a departure in circumstances where inherited or gifted funds are applied. Even if the court were to decide that special circumstances exist and that those special circumstances should result in an unequal sharing, we then need to think about quantification, which has become another issue in itself. In the case of Harris, which I mentioned a couple of seconds ago, the sheriff said there was no requirement that the sum paid is the sum to be paid out on an unequal share. So he's really just saying, look, you may have put in, say, £200,000, but that's not necessarily what you're going to get back. In the case of G against G, 2016 Family Law Review 30, although the court didn't take the stance taken in Cunningham as constituting a general rule, the husband achieving an unequal division due to the source of funds argument, he didn't get back the whole amount of his original contribution. And cases in which this has happened just really illustrate that there are different ways to tackle the issue of quantification, ranging from the broad brush to a more forensic approach. Different people will have very different notions of what's fair. Should the person claw back the original contribution? Should an uplift be applied to take into account the increase in value of the asset to which the special circumstances argument applies? Or there might be other balancing considerations in the mix as well, such as perhaps the other spouse having arguments in relation to economic disadvantage, perhaps giving up a career to care for children, therefore missing out on pension provision, career progression, income. It can all become a wee bit of a nightmare, but sometimes these arguments can be offset against each other, bringing us back to what's effectively an equal sharing position. Because when you look at the time involved in taking these cases to proof, the cost involved, the stress caused by the uncertainty, quite often where we end up is that equal sharing is the norm. That's the advice that should be tendered to a client, and that's how the vast majority of cases do end up. I think the situation becomes more complicated if we're looking at a long marriage, or where, for example, the first jointly owned house might have been bought using gifted or inherited or premarital savings, i.e. anything that on the face of it might be excluded from the definition of matrimonial property, but then that property is sold and the money rolled over into the next property or the next one, and so on and so forth. And I think that what we can draw from the case law so far is that the intermingling of funds makes it harder, firstly, to prove the existence of a special circumstances argument, because the tracing exercise will be harder. And secondly, the court might take the view, as they did in Harris, that the longer the marriage and the earlier the gifted or inherited funds were received or used to purchase matrimonial property, greater the effect on the substance and the valuation of any source of funds argument. So I think the Harris case is a really useful one for us to bear in mind. It sets out a number of helpful points to remember when looking at how a court might treat special circumstances arguments. It does underline that the broad policy underlying section 9(1)A is that equal sharing applies to the fruits of the economic efforts of the parties during the marriage. So there may be a special circumstances where the assets used to acquire the matrimonial property were not derived from the income or efforts parties, but it also notes the extent to which the parties regarded the inherited or gifted property used to purchase matrimonial property as being part of general family funds, which I think in the majority of cases is what people understand. Yes, you might have been gifted money before we married and then you used it to buy the house, but you know, this was considered during the marriage as part of the general pot. Since the Harris decision came out, certainly one of my colleagues feels that the landscape's become a wee bit more structured, but really the reality now is I think there hasn't been much by way of consistency of approach. The court still has a very wide degree of discretion when it comes to A, accepting a special circumstances argument, and B, quantifying it. I suppose from my perspective, the fact that Lady Wise in the Court of Session has recently said, and I'm very much paraphrasing, you need to be going some to succeed in one of these arguments. That for me is just a sort of clear reinstatement that really the 50-50 is the norm and that should be applying. One thing that I did wonder about in the sort of scenario that I raised as an example there, husband might have a professional negligence claim against the conveyancing solicitors who I suppose allowed him to take title in equal shares, or who maybe didn't advise that an agreement of some sort would be recommended. I think if one of your clients is proposing to put money into a jointly owned property during a marriage, it's a hard conversation to have, but it might be helpful to say a post-nuptial agreement might be really helpful just to acknowledge that in the unfortunate event of separation, the intention is that that money would go back to the person who contributed it. You might find that you're never actually in a position where a client talks to you about that or consults you about that. But I think if they did, it would certainly be worth having the conversation. So how do we deal with all this in practice? I think all we can really do is flag up the legal position to clients, the dubiety that exists around these cases and how they're going to be treated, and just always remember that the cost involved in litigation can sometimes very closely align with the amount that they're arguing over. There was a case in 2018, just known as F against R, which really reinforced the need for conveyancing solicitors, particularly, to be alive to the issue of potential relationship breakdown. So what happened in this case was that the couple were divorcing, they were separated, decided to be divorced. The main issue around financial provision was whether or not a house purchased by the husband defender before the marriage was matrimonial property, i.e. was it acquired with the intention of being the family home? Husband said, nope, it wasn't. We weren't planning to marry at that stage. The relationship was pretty volatile. The intention was that the pursuer, the wife, lived there as a tenant and friend, which is a wee bit odd. The pursuer wife argued that it was matrimonial property on the basis that at the point the property was purchased, they were a couple as opposed to just being friends. So really the issue turned on the nature of the parties' relationship at the time of purchase. The sheriff decided that the property was not acquired with the intention of becoming the family home, and as such it was not matrimonial property. A huge amount of evidence was led in relation to the nature of the relationship. But what was interesting to note was that the conveyancing solicitor acting for the husband had given him advice at the point of purchase to the effect that he might want to consider a cohabitation agreement or a prenuptial agreement. The defender had been really clear in his instructions to his solicitor that he thought neither would be appropriate because he thought that they were neither cohabiting or contemplating marriage. The fact that the solicitor had covered this off in discussions, though, and could demonstrate that in the context of the divorce action was ultimately helpful to the defender in his argument that the house was not matrimonial property. So I suppose the sort of learning point that comes from that case is just to remember always to document things really, really carefully in your file as well. Is there any way in which people can go into a marriage, or even during a marriage, set out how they want matters to be resolved in the event of separation? Well, yes, they can. And the answer to that would lie in the form of a prenuptial or a postnuptial agreement. Historically, I think these were sort of seen as a celebrity accessory, but you don't need to have celebrity clients to be asked to advise on these. And in fact, they do seem to me to be becoming a bit more common now. And the most common reason for entering into an agreement is in order to exclude certain property from the ultimate division on separation. I wanted to say a wee bit just about prenuptial agreements or postnuptial agreements and what can realistically be achieved, because they are cropping up more and more in my practice, and I wonder if it's the same for everyone else. But although parties are free to contract in Scots law in any way they want, they could technically decide to contract out of the scheme of financial provision set out in the 1985 Act. There isn't much authority really on how effective such agreements are. My concern would be that any attempt to contract out of the 1985 framework altogether might be open to challenge. So I think really that the further you go from the framework, the more likely it might be that any agreement would be disputed. And of course, in terms of the 1985 Act, the terms of any agreement entered into between the parties is a relevant factor in looking at the overall division. It could be possible, or it is possible, to have a more wide-ranging provision in a prenuptial or a postnuptial agreement, where what you're doing is setting out a separate property regime. So what you're really just doing is documenting that certain property or income derived from properties would be sort of left out of account at a later date on separation. So, for example, you might have an agreement that would say Mr. Bloggs agrees that his separate property constitutes blah, 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 and Mrs. would agree to that as well. And then there'd be a mirror clause just listing what her premarital assets were. And that can be useful in cases where somebody is introducing funds that have been gifted to them or that they've acquired by inheritance, because it just sort of underlines what their intention would be on separation. Your provision could go even further to cover, for example, rental income derived from a property that was acquired before the marriage by one of the spouses. So just to always go back to these concepts of fairness and reasonableness when you're assessing any possible claim. But I think there are things that we can do as solicitors to try and sort of mitigate claims. If that's what clients would be concerned about, then by all means advise them about prenuptial agreements or postnuptial agreements. I think an interesting case to just look at, and it's related to financial provision and the issue of agreements. It's a case called Kibble against Kibble, and the citation is 2010 SLT Sheriff Court number 5. It really deals with the provision in the 1985 Act that allows certain agreements to be set aside. Setting aside can only be done on divorce. Successful challenges to agreements are rare, but again, I think we need to be aware of the risks when looking at agreements, that they can be set aside under Section 16 of the 1985 Act. So what that provision states, and it's discussed in quite a bit of detail in the Kibble case, the court could make an order setting aside or varying any term of the agreement relating to periodical allowance where the agreement expressly provides for setting aside or variation by the court of that term, the agreement or any term of it where the agreement was not fair and reasonable at the time it was entered into. Now, the leading case on whether or not an agreement was fair and reasonable at the time it was entered into is Gillen against Gillen, 1995 SLT 678, and it confirms or outlines the principles that a court should consider when determining whether to set aside an agreement. And these are as follows. An agreement should be examined from the point of view of both fairness and reasonableness. All relevant circumstances leading up to and prevailing at the time of execution of the agreement need to be considered, including the quality and nature of legal advice given to either party, Evidence that some unfair advantage has been taken by one party of the other by reason of circumstances prevailing at the time of negotiations may have a cogent bearing on the determination of the issue. The court should not be unduly ready to overturn agreements validly entered into, and the fact that it later transpires that an agreement had led to an unequal and possibly very unequal division of assets does not by itself necessarily give rise to any inference of unfairness or unreasonableness. So what had happened in the Gillen case was that the wife wanted to set aside the terms of a minute of agreement. She'd given up the right to aliment and claims to certain of her husband's assets, including his pension. In exchange, she'd been given the right to buy him out of his share of the former family home and at a discounted price. She realised under the 1985 Act that she would actually have got a better deal if she had claimed financial provision in terms of the legislation. So a sort of pragmatic deal was done. She was happy with it at the time, but she later thought, actually, I would have got more if I had gone after his pension, I think that's how she put it. The court, however, refused to set that minute of agreement aside and said that she'd really achieved what she'd wanted to achieve at the time, and none of the factors that would tend to suggest that an agreement should be overturned in terms of Section 16 applied in the Gillen case. And these principles were underlined more recently in the case of Bradley against Bradley, and that's Bradley against Bradley 2017, SAC 29. The sheriff at first instance did set aside an agreement, but that was later overturned on appeal. And again, the key words that were used were that the husband had achieved what he'd wanted to achieve at the time. So I suppose if you think that a client might want a pre or post-nuptial agreement, they confirm that's what they want to do, make sure they do think carefully about the family law implications should they then decide to separate, and just any challenges that might be made to an agreement. Just moving on to the case law, 2020 was not great in terms of financial provision case law, but there were a few cases that are worth mentioning, and I'm going to just sort of skip through them really. The first case that I wanted to look at, because it's quite an important case in terms of how bankruptcy can affect financial provision divorce, is a case called CVC, and it's 2018 WL, and the citation I have is 059830. So it's a Westlaw citation. Pursuer husband was 52, the defender wife was 63. They separated in 2012. They'd been living together for about 6 years before marriage. In 2007, the husband was sequestrated, and administration of the estate went on until 2014, so after the relevant date. Husband had transferred his 1/2 share of the matrimonial home to the wife. Trustee challenged that, and what ultimately happened was that wife agreed to pay £63,000 back to the trustee without any admission of liability. But I think that the key thing to remember from that case is that we need to be mindful where sequestration is maybe in the offing about how any agreement reached on separation might be affected by the trustee's interests. The figures in the C case are sort of relatively complicated. Really, husband had been saying, well, look, the debts that led to my sequestration were matrimonial. They should be deducted from the net value of the matrimonial property before any balance is fairly shared between us. He had incurred the debts during the marriage, and they mostly related to business interests. Had the business interests been going concerns at the relevant date, the value of those interests would have comprised matrimonial property, so the debt associated with them would have been taken into account in that context. Wife was saying, look, in return for me paying a capital sum to the trustee, husband had agreed that he wouldn't seek to make any claim on my remaining assets. And she tried to argue that the sequestration debts, for want of a better way to put it, were not matrimonial debts. They'd operated separate finances through the marriage. She'd maintained all payments in relation to the family home and looking after the kids when they were growing up. with little contribution from husband. So she was really trying to say, look, if we look at these circumstances in the round, fairness would dictate that I really don't need to be liable for these debts at all. What the sheriff did was say, actually, neither of you have pleadings that properly reflect the evidence that emerged. Wife had averred that the husband was sequestrated because of gambling debts, purchasing racehorses, and involvement in other dodgy transactions. She'd actually led no evidence in support of those averments. And what the sheriff said was, in determining the net value of the matrimonial property, I have to give regard to section 10(2) of the Act, finding that the words any debts must mean just what it says, any financial obligation incurred by either party during the course of the marriage, regardless of the cause of it. So the sheriff had gone on to say, even if I'm wrong about that, and I have wrongly interpreted section 10(2), the evidence which was led showed that the debts incurred were not just incurred by the pursuer for selfish and non-matrimonial purposes and reasons. There was no evidence from the wife or any other witness which would help persuade the sheriff that the debt had been built up as a result of extravagant personal expenditure. So the residual value of the matrimonial property at the relevant date factored in the amount that was due to the trustee. It's an interesting case to read if you've got time, because it also covers off the issue of or pleadings around economic advantage. Wife was trying to say husband gained an economic advantage as a result of my efforts and I've been disadvantaged. She was also saying that the husband's conduct had adversely affected the financial resources available. And she was also sort of, really trying to kind of underline that these debts should not in any way be her responsibility. In terms of just pleading, I think that pleadings and the fact that the pleadings didn't actually bear any resemblance to the evidence that was given seems to have been a real factor for the sheriff in this case. So I suppose it's just a reminder that when you're doing your pleadings in a complex financial provision case, just check that that's what the evidence is likely to bring out. There was also an issue in the C case about whether there had been any agreement between husband and wife that the debts should be waived in exchange for a payment to be made by her, and the court just said that there was nothing to suggest that there ever was any agreement, verbal or otherwise. There was a file note from a solicitor on the file who had advised both parties at the date of separation that it only recorded a sort of tentative discussion and nothing more than a potential agreement. So it's a useful case to look at as well if you're thinking about whether there was actually an agreement between parties or not. C against C really has it all. It's also got a special circumstances argument around financial arrangements and whether the couple's financial arrangements during the marriage had been acceptable to the wife or not. Again, the sheriff kind of sidestepped an awful lot of it and said, look, none of this is terribly relevant. For 5 years of this 18-year marriage, the husband's contributions to the finances were really negligible. The wife hadn't worked when the wife was looking after the children. After the kids were born, she'd given up work to look after them. And the sheriff commented that her contribution could be recognised as caring for the children, keeping the home and putting aside whatever career ambitions she had. But what he wasn't willing to do was to start sort of saying, well, had you not been looking after the children, you might have earned X and your pension might have been Y. He just didn't go there. In that case, conversely, the husband had no pension plan or provision, but the wife did. Husband had craved a pension sharing order, and there were these quite convoluted arguments about special circumstances. But the sheriff decided that it would be fundamentally unfair for the husband to derive any benefit from pension arrangements which were earned solely by the wife through her own contribution. So maybe on one view, that is the sheriff sort of giving her some recognition of her non-financial contributions. But fairness in this case is really quite sort of objective, I think. Also in 2020, we were delivered a judgment of Sheriff Anwar at Glasgow Sheriff Court, case of AF against AF. And it's The citation is 2019 Session Cases GLA 22. It was a case of divorce and financial provision. It referred to just a horribly unhappy marriage. It sounded terrible. The couple had separated in February 2013. The husband had behaved quite badly post-separation. The matrimonial property was held in unequal shares, so the matrimonial home was worth 220,000. Title was taken in the name of the wife and her eldest son to the extent of 75% and 25%. There was a plot of land. The wife had an interest in her own beauty salon. There were properties in Pakistan. There was cash, and there were a few small matrimonial debts. Really, the issue in this case is to do with evidence, and in particular, expert evidence. Quite a funny judgment to read. The wife sought no orders, but she did oppose the granting of decree of divorce. Husband had tried to argue that he couldn't work in the UK due to his immigration status, but he had contributed significantly to the purchase of the property. The pursuer also sought to lead evidence, and this is where it gets good, from a skilled witness in relation to the value of property in Pakistan, Mr. Fayaz, who gave evidence from Pakistan by live TV link. No CV was provided for Mr. Fayaz, nor was any letter of instruction or expert report provided. And Sheriff Anwar didn't find the pursuer's evidence credible. She held that it was coloured by his anger at the defender for excluding him from the house, and also that his supporting witness, his brother, had given evidence tailored to support his position. However, the wife's evidence was also held to be unreliable and lacking in credibility. The sheriff referred to the conduct of the case as an abject lesson, so quite strong words, to those coming to court seeking financial provision. She granted the divorce. She held that the pursuer had failed to discharge the onus of proof in respect of financial provision, and she said that the burden rests upon the party seeking financial provision. So it's not a particularly happy tale. I think even if the sort of required information about valuations had been made available to the court, the sheriff still wouldn't have made an order for financial provision, because she would have had to find that there were special circumstances justifying a departure from equal sharing, namely the source of funds used to purchase property in Pakistan. The conduct of the husband, who seems to have dissipated the family finances, is a relevant factor, but she would not have granted a division of the matrimonial property. She doesn't say what she would have done had all the vouching been in place and had she been satisfied about people's credibility. It's probably one of the more entertaining case reports that you could ever read. If you're going to read one, read that one. Fox against Fox, 2019, SC STI 3. This is a decision of Sheriff Collins sitting in Stirling Sheriff Court. It's quite a complicated case. Husband was 46, defender 39. She was a US citizen. They both worked throughout the marriage. They both contributed all earnings during the marriage. His earnings were higher than wife's. In some years, though, the wife's earnings had exceeded husband's earnings. Both parties had various savings pre-marriage. Husband used his savings and his ISA to fund the deposit for a house which they had purchased at the beginning of the marriage in joint names. So at the relevant date, we had the house, we had his pension. His total pension entitlement was just about £80,000. Wife's total pension entitlement was just under £65,000. Husband had shares which were worth in total £38,000, and there were some relatively small bank account balances. The wife sought transfer of the house. Both parties sought an unequal division of the net value of the matrimonial property. Both referred to special circumstances in terms of section 10.6. Both argued there were considerations of economic advantage and disadvantage under section 9.1b, and the need to achieve fair sharing of the economic burden of sharing the care of the children under section 9.1c. There was an issue about what the former matrimonial home was actually worth, but what was clear was that the balance of the mortgage had been reduced by the wife's contributions. Both solicitors argued that the net value of the matrimonial home for present purposes should be the value at the date of separation less the mortgage at the date of proof. However, Sheriff Collins didn't accept that. And he said that no account could be taken of changes to the value of matrimonial property which occurred post-separation. And I think that's right. The insertion of section 10(3)A to the 1985 Act had the effect that where an order for transfer is made under section 8(1)AA, the net value of the property is determined at the appropriate valuation date, which is a date agreed with the parties, or which, failing the date of the making of the property transfer order, or in exceptional circumstances, such other date as near as may be to the date of transfer as the court may determine. So what the sheriff did in relation to the issue of the wife making mortgage payments was to use the net value at the appropriate valuation date, i.e. the date of making the property transfer order or the current date, which took into account the fact that the house value had not risen, but the balance of the mortgage had fallen. Husband was arguing that a £9,000 gift from his mum should be taken into account. The sheriff didn't find his evidence credible or reliable, but what the sheriff said was, look, you didn't ring fence this money in a separate savings account. You didn't spend it on any particular item. It was used for day-to-day spending. The money was decided to be a gift. It was not matrimonial property. And if it could have been traced to an identifiable item of matrimonial property, there would have been grounds for an argument for unequal division under in 6B, our source of funds arguments. Husband tried to argue that the fact that he was paying more of the day-to-day expenditure for the house while he was a higher earner should be taken into account, but the sheriff didn't seem to have very much sympathy for that. Wife was arguing the sort of traditional economic burden of childcare. I want a 60-40 split. She was running that line. She was saying that child maintenance as assessed by the CMS was inadequate, and that the husband had deliberately failed to pay all child maintenance falling due. Now, the shortfall at the time of proof was about £1,000. She also tried to say his employment history is such that there is a risk he might lose his job in future and wouldn't be able to pay child support at all. The factors which the court found relevant are as follows. The child was in good health with no special needs, so childcare costs would be no greater than normal. The child was at the local state school and was likely to continue to attend. The wife did not suffer any loss of earning capacity due to the need to care for the child, but she did have expenditure caused by caring for the child after school and also having to have a childminder and pay for school holiday clubs. Childcare arrangements, however, allowed the wife the freedom to work and to continue to develop her own career. The husband's earnings were less and his income was less consistent given his health and employment problems. Therefore, his wife was actually better able to afford the greater burden of childcare costs. It would not be equitable for the wife to obtain a capital sum to guard against the risk of a reduction in contributions from the husband to her ongoing costs. The sheriff wasn't prepared to accept that there would be a greater than normal risk of him losing his job. And he also commented that the transfer of the house to the wife secured accommodation for the child, whereas the husband's accommodation required to be revisited because he hadn't been able to purchase a settled property pending determination of the proof. Both parties had provided schedules of childcare costs, and the sheriff was critical of both schedules. While part of the costs incurred by the wife were necessary to enable her to continue work, other costs such as birthday presents and parties, presumably children's parties, were paid by her because she could afford to do it. And there was an element of choice on her part in that regard. The ability to pay for these items were the product of the success of her career. The husband's contact costs in his schedule were at certain parts thought to have been exaggerated. So the sheriff found that to unequally divide the matrimonial property sought by the wife would reduce the capital payment to the husband and reduce his ability to purchase accommodation in which he could exercise contact. He also took section 11.3a quite broadly to include payment of a child maintenance assessment under the expression arrangement for aliment for the child. And that's never been done before, to my knowledge, by a sheriff. And I think many agents might think it's a bit of a stretch, but what he said was there was no justification for an uneven division of matrimonial property to take into account the burden of childcare. The wife had sought effectively return of some of the mortgage payments, and he was saying, well, so what, I had to pay rent during that same time period. You had a comfortable house to live in while I was sharing a room in a shared house. And the wife did reject the wife's claim. And what he said was it was inevitable that one of them was going to have to move out, and it wasn't unreasonable for the husband to do so. It was in the child's best interest to live with the wife and to do so in the house. Husband therefore incurred accommodation costs, and it was not unreasonable for him to rent rather than trying to purchase pending final determination of the case. The wife had the benefit of living in the matrimonial home with greater amenities than the husband did. The wife had not let out the spare room in the house to a lodger to reduce mortgage costs. And also, wife's new partner had been living in the house since 2017 without making any contribution. So Sheriff Collins wasn't terribly sympathetic. So the sheriff was satisfied that sharing the value of the house at the appropriate valuation date would be achieved by equal sharing. Equal division was fair sharing. Each party would be entitled to 136,000 if division was to be effected by a transfer of property to the wife. So the wife had to make payment to her husband of £24,000. I mentioned earlier that the case of A against A, it's on the Scottish Courts website. It's fairly recent, I think it was August. It's a case which covers off financial provision on divorce generally, but it also looks at valuation of company shares. It considers, interestingly, the effect of the pandemic upon how financial provision should be structured. So what Lady Wise doesn't accept is that a downturn in business justifies valuing a property or shares in a business at a lower value. She values the business at the relevant date, but what she does do is accept that because of the pandemic downturn in business, the husband's resources have been affected, and what she decides to do is make the capital sum payable by instalments. And there's then a discussion at appeal level about the way the interest was awarded on those instalment payments. But it is a really interesting case generally, and it is the case in which she underlines that as an observation that gifted or inherited funds do not necessarily give rise to unequal division. So there's quite a lot in there. As I said, it's quite a recent case, and it's quite an interesting one as well, just to see how Lady Wise looked at the contributions which the pursuer wife claimed to have made. So if anybody needs any citations or wants to just chat through any of the points that arise from the content of this talk, let me know.